Hello, everybody. My name is Juan Carlos Brando. Thank you for joining us today one more time with the Office of the Attorney Margaret W. Wong, who has been in the immigration field for over 40 years. She has a large immigration office in the city of Cleveland with offices located in 9 cities of the United States. And today we have the honor to talk to one of the attorneys that have been joining the team of more than 15 attorneys that the office has working together with our head attorney, Margaret W. Wong. And thank you, everyone, for having us today. The attorney that is joining us today is the attorney Nor Chamas. Is that the correct pronunciation?
It's Noor Shamas.
Noor Chamas.
Mhm.
Okay. Thank you so much for having us today.
Thank you
And
for
it's
having
an
me.
honor to have you. Just to start talking about a topic, a lot of people are asking what's going on with people that have tried to enter the United States in the last month or the last couple of weeks.
Okay, so
Yeah,
most
yeah.
recently there's been a decision by the Biden administration to kind of expedite the removal of families that are entering at the southern border. Um, the administration says that they've been seeing an increase in the amount of people attempting to cross the border, and so the decision that they have made and the policy that they have instituted now is to actually try to expedite the removal of people at the southern border. Um, and usually that process involves them interviewing the family, seeing what they're looking to do here in the US. A lot of times, even if they ask for asylum, where they say they claim fear of returning to their country, they're still denied entry and they're returned back. Unfortunately, this is the situation right now at the southern border. The administration obviously faces a lot of pressure from different groups and different political factions who are complaining about the number of people that are appearing at the border. And so one of the decisions they decided to make is to take that type of action against families at the southern border.
Okay, thank you so much, Attorney Nauer. And well, if a person is paroled in to the United States, um, can they apply for a work authorization right away, or they need to file for an asylum application?
So well, first of all, being paroled into the United States is a positive thing because it allows you to actually qualify for adjustment of status if you have somebody that can petition for you. You wouldn't have to actually go back and do consular processing. However, in terms of a work authorization, you can only file for work authorization when you have either a pending application with USCIS or with the court, or if you are put under supervision, an order of supervision, at which point you can file for work authorization. For asylum purposes, if you do file for asylum, you can file for work authorization. Under the new rules that were instituted at the time of the Trump administration, which began in August of last year, you actually have to wait 365 days before you qualify for a work permit, unless you are a member of a specific class of people that filed a lawsuit and received a settlement, allowing them to still obtain a work authorization after 6 months of filing an application for asylum.
Okay, so it's very interesting. Honestly, I didn't know that this could be done. I thought we had to wait until they had asylum application pending or something like that. But this is good. So if you have any questions, please don't hesitate to write them down, and we will be happy to answer your questions. The attorney Noor Shamas is with us today, and you can call for more information to 216-279-3984, 216-279-3984. So we have questions coming in through our inbox. And I will begin with the first that we have here. Arturo is asking, I have a question, and I would like to know the starting expenses for filing H-1B applications. This person is from Thailand.
Oh, okay. Well, I mean, in order to file for an H-1B, the first thing you have to do is get a labor conditions application filed with the Department of Labor, and that has to be approved. And then right after that, you file for an I-129, which is an employment-based non-immigrant application. In terms of the total expenses, minus the attorney's fees, you're looking at somewhere around $2,000. But with attorney's fees, depending on what the fees are, you're looking at well beyond that. It's hard for me to answer that question here. You would want to get a consultation for that specific purpose, so you can figure out exactly what your expenses would be.
Okay, thank you so much, Attorney Nauer. And we have another question coming in through our inbox. And this is saying, I want to get a work permit. I am from Mexico. What do I need to do?
So as I stated earlier, you can't just file for a work permit. You have to have a pending application unless you are placed under order of supervision, which is when you actually have a final order of removal, but the Immigration and Customs Enforcement has elected not to remove you or is unable to remove you. They put you under order of supervision. On that basis, you can also ask for a work permit or apply for employment authorization. However, any other time, you have to have some pending application that allows you to file for work authorization. For example, if you file for adjustment of status, that's one way. You can also, based on a pending adjustment of status application, file for employment authorization. Or if you have a cancellation of removal application with the court, you can also file based on that. And if you have a pending asylum application, you can also file based on that, except that you have a longer waiting period before you would be eligible for work authorization.
Okay, thank you so much, attorney. And don't forget that the phone number that you can call to talk to one of our attorneys is 216-279-3984, 216-279-3984. The office of the attorney Margaret W. Wong has offices in 9 cities of the United States, which starts in Atlanta, Cleveland, Columbus, Chicago, Memphis, Minneapolis, Nashville, New York, and Raleigh, North Carolina. And she has representation in all of those cities. And the attorneys can go to your interview, to your court hearing, and they will take care of your immigration needs. So the phone number is 216-279-3984, 216-279-3984, and they will be happy to go to any of those cities. And it doesn't matter if you are in Texas or California waiting for a hearing. Our attorneys can travel to your city and represent you in front of the immigration court. The next question, attorney, is saying the following. Good morning. My name is Morphy. I am a victim of deportation in 2017. I want to see if you can help me fight for my case. Thank you so much. And what could I do? I think this person was deported, and by the name Attorney Nauer, I assume is from some part of Asia.
Okay. So, there's a lot of ways to answer this question. It depends on what the specific facts are of that individual's case. If you are ordered removed and you are physically deported, at that point, you could still potentially, obtain an immigrant or non-immigrant visa to the U.S. You would have to file a waiver. So for people who are deported, let's say they have an immediate relative, say they're married to a U.S. citizen, and that person petitions for them. Now, normally when you have an order of deportation, there is what is called a 10-year inadmissibility bar. That means that you are not eligible to apply for any visa to the U.S. for 10 years from the time that you are deported. However, if you are, let's say, married to a U.S. citizen, that U.S. citizen can file a petition for you, and once that's approved, you could file an application for an immigrant visa along with what is called an advance permission to be for admission into the U.S., which is an I-212 form. However, also, if before you are deported, you have accrued more than 1 year of unlawful presence in the U.S., that's an additional 10-year inadmissibility bar. And for that, you would also require a separate waiver. It's an I-601 unlawful presence waiver that you have to file along with the I-212 application for admission to the U.S. So there's ways you can go about it, but it depends on specific facts. If you have serious criminal convictions, you won't be able to apply for admission to the U.S. If you don't have an immediate relative who's a U.S. citizen, that makes it even more difficult for you. Other examples are, let's say you apply for a U visa because you were a victim of a crime in the U.S. and you did cooperate and aid law enforcement in the prosecution of the perpetrator. You could qualify for a U visa, and if you are approved, you can actually waive either your unlawful presence or your deportation and be allowed to enter the U.S. as a non-immigrant, as a U non-immigrant at that point. But I mean, as I said, depending on the facts, there could be things that you could do, but we would need to know more.
Thank you so much, Attorney Nar. And the next question is coming from a lady. She says the following. I don't live in the United States. I live in Colombia, but I am a book writer. And those books are registered and sold in the United States. Do I need to pay taxes for those books there in the United States? And the reason of my question is because I am thinking about moving there and start a business in that country. She means in the United States.
Right. I mean, to answer that question accurately, I would have to say that I'm not a tax attorney, so I wouldn't want to say anything that would be false. I would advise that you consult with a tax attorney to find out exactly what taxes you would have to pay or not pay up until you come and live in the U.S. Obviously, if you are in the U.S. and you're making an income in the U.S., you would be required to pay taxes for that income. But in terms of your specific question, I would advise that you consult with a tax attorney for that.
Okay, thank you so much. Next question, but before we keep going with the next question, don't forget that the attorney Nar Chamas, he's working with the attorney Margaret W. Wong, who has been working on this field for over 40 years. And they are working together. They go to court. They are doing a lot of things that are good for your immigration needs. So if you need advice, don't hesitate to send your question free right now, and he will answer for free. And also, you can call for more information to 216-279-3984, 216-279-3984, the attorney Margaret W. Wong and her office. This next question is very interesting because it's this person. Let me understand this question. Okay, I want to know what the U visa means because I was victim of robbery in my house. Two guys with face covers entered to my house and they threatened my family with a fire gun. My question is, can I apply for the U visa even though I wasn't there? My husband and my kids were in the house, but I was at work.
Okay, so first of all, the U visa or the U non-immigrant status is for people who are victims of specific crimes or specific types of crimes that are listed in the Immigration and Nationality Act. Now, robbery itself is actually not included as one of those crimes. However, there are other crimes that are included that could fall under the fact that the facts of your specific case. So if you were, say, assaulted, if you were like threatened at gunpoint, that could be an assault. You could use that because assault is one of the crimes that is listed in the INA for U visa purposes. Now, the other thing is if you were not there, but your children or your husband was there, one is if your husband is not a citizen or a resident and files for a U visa, you can be a derivative of that U visa application. But also you can actually file as an indirect victim of your children if your children are minors. So there's ways that you can do it depending on your specific facts and qualify for a U visa. We would have to look into that more. So if you would like, you can call our office for a consultation and we'll definitely give you more information about that.
Thank you so much, attorney. And don't forget that the phone number is 216-279-3984, 216-279-3984. This next question says, could I apply for H-1B visa while I am in the United States? My B-1, B-2 visa is still current.
If you have a current valid visa, you could apply for an H-1B and do a change of status. Everything would have to happen before your visa expires. But again, everything depends on your specific facts, whether or not you would qualify for an H-1B visa. So again, I would always urge you to consult our office, call our office, and we would happily give you a consultation to find out what you can qualify for.
Thank you so much, attorney. Don't forget, if you want more information, the phone number is 216-279-3984, 216-279-3984. Hi, I am from India. My uncle owns a hotel in Chicago. Can he petition me?
Well, the uncle can't petition for you as a family member, so that a family-based petition would have to be either by one of the listed family members in the law. So it could be your parents, your children, your siblings can petition for you, but any outside family member cannot. However, if you are looking into your uncle or your uncle's business petitioning for you on an employment-based visa, that would be possible depending on what your profession is, what your position would be, what visa they would petition for. So there's a lot of different information that we would need to know in order to better answer that question.
Thank you so much, attorney. And don't forget that the phone number is 216-279-3984, 216-279-3984. So we have a next question. I am from Colombia. I am married to an U.S. citizen, and he filed for me, but immigration said that he has not enough money for me to petition me or to sponsor me. They asked for a joint sponsor, and I would like to know what the conditions of the joint sponsor should be.
So anybody can be a joint sponsor as long as they are a lawful permanent resident or a U.S. citizen that is domiciled in the United States. And obviously they would have to make sufficient income to qualify as a sponsor. The specific income that is required is in the poverty guidelines that is provided by the Immigration Service. So it'll tell you exactly how much you have to make depending on how many people are in your household. So as long as you make sufficient income, you are a U.S. citizen or a lawful permanent resident, and you are domiciled in the United States, you can be a joint sponsor.
Okay, thank you so much, attorney. Yes, and actually, this could happen to a lot of people. So before you do anything, before you file for anything, please get in touch with our attorneys, and they will advise you to whatever you need to do in the immigration field. This next question says, I came to the United States with my parents. I am turning 18. We have been waiting for our green card since we got the asylum grant 3 years ago. And I am turning 18, but I'm concerned that I will be out of the application, and I don't know if my green card will be coming or if there is any change because I am turning 18.
Well, if you are granted asylum, then you should be able to apply for adjustment of status 1 year after your asylum grant, but you have to file for it. It doesn't automatically come. So after 1 year of being granted asylum, you need to file Form I-485, which is the adjustment of status application, in order to then become a lawful permanent resident. If you have been granted asylum, then you shouldn't be worried. You should be able to still file for asylum. Since you have an asylum, I'm sorry, for adjustment of status since you have an asylum grant. But again, you need to file the application. It won't come automatically.
Okay, thank you so much for this answer. This next question is coming from a person who is from Italy. And she says, I have the nationality of Italy. I was born in Argentina, and I'm currently living in Italy. I used to study in the United States, and I did my internship um, in the city council of Atlanta, um, because I was studying uh, politics, and I would like to know if now with my Italian passport I could go back to the United States and try to start working for someone, or if they need to petition me first and then I move to the United States.
Okay, so well, first of all, you can't work in the United States unless you either have employment authorization or you have a visa that will allow you to work in the United States. So if you're coming here for employment, then whatever company you're looking to work for will need to sponsor you and file a petition for you. Outside of that, you won't be able to come to work in the United States unless of course you're the beneficiary of a family-based petition and you adjust status and become a lawful permanent resident. But if you do want to come strictly to work in the U.S., you have to have somebody sponsor you and petition for you.
Thank you so much, attorney, for this answer. And this next question is, I am a business administrator. My brother-in-law is owns a clinic in the United States. He wants me to come and help. Uh, I think it's a very similar question to the one before. Can they apply for this employment-based visa?
Yes, there are employment-based visas that could be available to you. Again, there's other facts that we would need to know, what position you would come here to take, what your background is, what your profession is, what your degrees are. There's a lot of different things that we need to know in order to find out what the best employment-based visa would be for you. But there are employment-based visas available that you could be the beneficiary of.
Okay, thank you so much. And this next question is, this person says, I came through Mexico. I surrendered. I gave up myself in the southern border. I was detained for 1 month, and then I was released. I am living with my brother, but I would like to know what I need to do, if I need to apply for the asylum or if I need to wait for the court date.
So again, I'm not sure exactly of the facts. It sounds to me like you were placed in removal proceedings and that you would have immigration court proceedings coming up. Now, if you do want to file for asylum, keep in mind that you need to file for asylum within 1 year of entering the United States. So regardless of whether or not you get a court date, you need to file that asylum application. Otherwise, you could be deemed not to qualify for asylum if you file beyond the 1 year. As far as other details about what else you can do, I can't say. I don't know what your specific facts are and what else you would qualify for. If you call our office, we will be happy to give you a consultation and explain to you what your options are.
Thank you so much, attorney. Don't forget that the phone number is 216-279-3984, 216-279-3984. The attorney Margaret Wong has more than 10 attorneys working with her in the office and in the different offices that she has placed in the United States. So if you need more information, please give us a call. It doesn't matter in what city you are. you can call 216-279-3984, 216-279-3984, and she will be happy to help you with your immigration needs. She also has set up the video consultation or telephone consultation during the pandemic, and now that we are getting out of the pandemic, despite of all the comments that people are saying and all the gossip around the COVID pandemic, we are still doing telephonic consultation, video consultation, and also in-person consultations. So please give us a call, 216-279-3984, 216-279-3984. Attorney Shamas, can I travel abroad if I have a TPS approved but an asylum pending? I am from Venezuela.
Okay, so one thing you always have to be very careful of is that you should not travel abroad, even if you have TPS, unless you obtain an advance parole document. Without an advance parole, if you travel abroad, you could trigger an admissibility bar and you won't be able to come back to the US. So always, if you have TPS, regardless of what else you're doing, you need to get an advance parole document before you decide to leave the country. Otherwise, you could face many difficulties trying to come back in.
Okay. This next question is very interesting, attorney. This person says, I came with an R1 visa working for a church, which expires on Saturday after 5 years that I had it. I applied for the I-360 8 months ago, and it has not been approved. I don't know when that will be approved, but I don't want to stay out of status. I'm really, really worried about it. I was suggested to file a student visa, but now I have a question, which is, what happens if I receive the approval of my 360? Can I apply for the adjustment of status, or I still need to wait for my student visa to be approved?
If you get an approval of the I-360, then yes, you can apply for adjustment of status. The I-360 Special Immigrant Religious Worker Visa is an immigrant visa. It allows you to adjust status to that of a lawful permanent resident. As long as you file your applications before your visa expires, you will have authorization to remain in the United States pending the adjudication of your application. So once the I-360 is approved, you can qualify to apply for adjustment of status to lawful permanent resident.
Okay, that's perfect. So, Attorney Naur Chamas, thank you so much for having us today with all of the questions that are coming through our social media. For you today, representing the law firm of Margaret W. Wong and Associates. So, we really appreciate your time and your help today.
Thank you for having me. I appreciate it.
Thank you so much. And for everyone who has joined us today for this show, don't forget that you can call from any city of the United States, and the phone number is 216-279-3984, 216-279-3984. The attorney Margaret W. Wong has representation in attorneys all across the United States, and they can go to your immigration hearing and they can represent you. Also, they can file any application. Could it be 10-year cancellation, asylum, U visa, employment-based visa, family-based visas, and also the people that are coming through the border. Please get in touch with the attorney Margaret W. Wong. And the phone number is 216-279-3984, 216-279-3984. Attorney Margaret W. Wong. Thank you so much, and see you next time.